Appeals Division 1 is now in session.
Good morning. Please be seated. This is the time set for argument in the matter of State of Arizona versus Desmond Deshaun Warren, our criminal number 12-0481. Each side will have 20 minutes within which to make their arguments here this morning. Appellant may reserve some portion of that, entirely at your discretion. We have read the briefs. We're familiar with the record. So please keep that in mind as you make your arguments here this morning. We are recording of the proceedings, both audio and video. As you approach the podium, please identify yourself and your client. With that, counsel, you may proceed.
Good morning. My name is Michael Steinfeld. I represent the appellant, Desmond Warren. Now, there's two issues that I requested an oral argument on, but I'll be completely frank with you. I find one of them a heck of a lot more interesting, and that's the constitutional issue. Even though it's not necessarily the dispositive issue in this case, and the traffic stop could have more breadth in how this court deals with the case, frankly, I find the constitutional issue a little bit more interesting.
And, while that is an interesting issue, does your client get to complain about it? In other words, the statute would suggest that a person needs to volunteer that he has a weapon, but your guy is not being punished for having kept silent in the face of the statutory directive. He actually said something that wasn't true, probably.
Yes, he did lie. If I understand the court's question, there's really two ways that I could answer.
In other words, a person could complain if he is silent in the face of the statute telling him he needs to speak, mm-hmm. and he says, you can't punish me for being silent because the Constitution protects me. But your guy didn't remain silent.
I have two responses to that, Your Honor. The first one is that when we look at the court's or the state-cited authority in State v. Dells, what they noted was, first and foremost, a person has standing if they've been harmed in some way by the statute. Now, the way that this statute functions, because it compels an answer to a certain degree, and because it puts a person in the trilemma situation that was discussed in Murphy, he has standing the moment that he's placed into that trilemma situation.
Police didn't tell him, oh, by the way, there's a statute that says you have to tell us if you have a gun, did they?
No, but we presume that people know the law. It's the exact same reason that we can say ignorance isn't an excuse of the law. And so in that sort of a situation, because he's being compelled by the statute, regardless of whether or not he knew of it or not.
It's interesting you said, because I wasn't aware of the statute till I had to write an opinion about it a few months ago.
I wasn't aware of the statute until I got this case.
I kind of doubt your guy knew about it.
Well, and in all fairness, I would probably doubt that too. I think that's a fair point. But that lack of a factual record.
You kind of flip. I'm not.
No, and I understand that. I think that's actually why the waiver issue is actually part of the important issue on this record, though, Your Honor, is because had the issue arisen, it's certainly possible that I, having been the trial attorney and my client, could have set more of a record on it. Instead, it wasn't challenged below. And when it's not challenged below, the state's waived the issue.
Well, doesn't the case law stand for the proposition that if someone chooses to speak, that the Constitution does not protect their decision to speak and to lie?
It absolutely does stand for that proposition.
So without that protection, how is there standing?
There's still standing, Your Honor, because it's forcing an individual into that trilemma situation. Ultimately, while there's no protection for lying, the problem arises when a person doesn't have any avenue available to him or her to avoid that sort of a scenario. And that's what Murphy really got into and what Lefkowitz got into, is an individual can't be forced into a circumstance where all three options are negative.
But he had choices. He could have remained silent or he could have invoked his privilege.
He couldn't have remained silent, Your Honor. He couldn't have invoked his privilege. And the reason that he couldn't have done that,
He would have standing if he'd done that.
He has
to
standing.
raise this issue.
He is standing nonetheless. And actually, I guess that goes to kind of the secondary aspect of the standing analysis, which is when we look to the narrow exception. Because pragmatically, the way that the states argued the standing objection is akin to the vagueness and overbreadth analysis that's often given. However, there's a narrow exception that's been noted to that, which is when a statute or a regulation might deter the exercise of rights, then a person still has standing even if they didn't exercise those specific rights. Now, while that's been typically applied in a First Amendment setting, there's no basis for not applying it in this setting. In fact, there would be basis to apply it in this sort of setting, since a First Amendment right to speak carries a concomitant right to not speak. And because of that, an individual who would want to exercise their right to remain silent is being deterred from doing so, and as a result is also being deterred from exercising their First Amendment right to not speak. So it's also the statute's impact on an individual's attempt or desire to not speak. And that's really what confers standing to Desmond Warren in this case. And that's precisely what the lower court ended up ruling in this case, was because the statute, in effect, coerced some sort of a response and forced a person, in this case Desmond, into a situation where he had to make a difficult decision, and he had to make a decision about whether or not to testify or make a statement that was truthful and inculpate, or with either of the other two options, face prosecution for failing to provide an accurate answer. That coercion is really the fundamental point, and that's what the exception gets to. So because that exception applies, I would still say from a merits point of view, Desmond Warren still has standing. When we get into the actual discussion then on the merits of the constitutionality, I think a lot of this has gotten spread out to the point where it's losing focus. And what I mean by that is the focus on the Byers line of cases and the focus on the Quarles line of cases, neither of which are really applicable to this sort of a scenario. When we look to what is applicable, the narrow cases that are applicable are the Lefkowitz and the Murphy line of cases, which really dovetail in with how this statute's working. In both of those cases, the Supreme Court commented that it's improper to force a person into a trilemma situation. And that trilemma situation is a situation where a person can give an incriminating answer, can choose to remain silent and face some sort of penalty for that, or can choose to lie and face what in Murphy was described as perjury. In this particular case, though, because of the construction of the statute, because of how the statute works, what this statute does is it forces a person to make that trilemma decision, because that individual will either, one, give incriminating evidence against themselves, or two, lie and face prosecution under the statute, as was done in this case, or three, try to invoke and again face prosecution under that same statute. So because the statute goes so far as to actually penalize the attempt to try to invoke, it forces an individual into that trilemma situation. Now, that's different from the Byers line of cases. And the fundamental difference in the Byers line of cases is that the Supreme Court recognized in Byers that there was still a need to allow for a person to invoke. There's a difference between identification and statements that go to content matter, if you will. That identification is allowed because that's not necessarily the big link that Byers was concerned about. The more content-based analysis, though, or the content-based discussions, did you actually cause this accident? Why did you cause this accident? How did you cause this accident? Byers still recognized that a person could invoke their Fifth Amendment rights under their decision. So Byers doesn't necessarily answer what's happening in this case. The second aspect, or the second line of cases, is the Quarles line of cases. Now, in the Quarles line of cases, that was simply an exception to Miranda requirements. In effect, I'm not quarreling with Quarles. I agree 100% with Quarles in that it should apply, and that the officer should have had the ability to ask the question. What's being objected to is the criminalization of one's attempt to invoke. Had this statute not even existed, Desmond Warren would have faced prosecution, and his prosecution would have ended up in a conviction, and that would have been appropriate for false reporting to a law enforcement officer. That different statute demonstrates the scope of this particular statute. Because the false reporting statute actually applies only to affirmative lies and actually applies only to affirmative misrepresentations, that demonstrates the difference in scope that this statute has, and that this statute seeks to not just criminalize affirmative lies and misrepresentations, but rather also the invocation of silence. So from that perspective, Quarles certainly allows the officer to ask the question. Quarles does not authorize the legislature to penalize a person's right to invoke their right to remain silent at that point. Now, then when we get to how the lower court ended up deciding the issue, the Flores line of cases. The Flores line of cases has two fundamental distinctions. The first fundamental distinction is the question of who the statement is given to. Under Al-Khafagi and Wilson, those two courts addressed the issue in far more depth and noted that the individual who's being required to make a statement was making that statement not to police officers and thus not a government agent, but rather was being forced to make the concession or the statement to a common carrier. That's a big difference. The second fundamental difference is the nature of the contact, because the nature of a contact in a criminal setting is usually an involuntary contact. It's an officer stopping an individual or an officer arresting an individual, precisely as was done in this case. It was a traffic stop in this case. However, in the Al-Khafagi and Flores line of cases, it was a voluntary contact that the defendant was initiating. The defendant was choosing to go to a common carrier and try to ship weapons. That's not what the situation was here. If this was a more broadly applied sort of statute that required an individual to make an assertion or a statement that they have a weapon upon entering a restaurant, then it might fall in line with the Flores line of cases. Now, those two distinctions are important then when we reflect upon In Re MH and the test, if you will, that In Re MH put forth. The first aspect of the test is to question whether or not the statute or the regulation is in an area permeated by criminal statutes. In this case, misconduct involving weapons is certainly in an area permeated by criminal statutes. It's a regulation or a law that's placed in the criminal code within a certain chapter that designates criminal offenses. The regulation of weapons, which even under Flores they admitted was in an area permeated by criminal codes. And this statute itself is a criminal code. It actually sets forth a criminal regulation and prohibits certain conduct in a criminal nature. So clearly the first prong of In Re MH is met. Now, the second aspect of it, which is that it's aimed at a highly selective group, is still met because of the nature of who's being contacted and how this questioning arises. It's as a result of police contact. Now, in the state supplemental authority, it cited to an article, a law review article, in which it was noted that there were 539,344 stops. Now, keep in mind that the year that was done was 2009. At the time, there were 6.5 million people in Arizona. So even if we were to broaden it just to the notion of stops, we're already talking about less than 10% of the population who might be subjected to this. The other thing to keep in mind is the fact that the U.S. Supreme Court has already noted that individuals who are being stopped for traffic violations are already intrinsically suspected of some sort of criminal activity. That's why Terry stops can apply and Terry searches can apply in traffic stops.
Counsel, hang on just a sec. Now, isn't this provision that requires a person with a concealed weapon to reveal that, isn't it part of a change in statutes that liberalized when people can carry concealed weapons?
Yes, it is.
And so why isn't it fair for the legislature to say, look, we're going to let a lot of people carry concealed weapons that couldn't before, but we want you to make sure that the fact that you're carrying a concealed weapon is made known to any police officers you make contact?
I think that it's a fair thing to do if done the right way. And what's interesting about it is the change actually demonstrates the problem, if you will. Prior to this statute, the way that it worked was a person had to apply for a CCW license, a concealed carry weapon license. And in exchange for getting that, they agreed that whenever an officer approached them, they would reveal that they had the weapon. So it was a knowing and voluntary waiver that was attached to a privilege.
Yeah, but given your theory that everybody knows what the law is, why, when your guy looks at the law and he says, oh, it looks like I conceal weapons, but I'm going to have to tell a police officer if I have one, why isn't it fair to sort of, he's implicitly agreed to reveal the weapon because he's chosen to have concealed weapon?
Because there's a fundamental difference in premising the availability of privileges versus the availability of rights, is how I would answer that question. When the legislature acted, what the legislature did was move carrying concealed weapons from the venue of privileges into the venue of rights. And it was simply another method of exercising one's right to have a weapon, which of course can have limitations within itself, but those are typically along the lines of felons who might possess weapons, and thus there's some sort of knowing conduct that comes along with it. it's improper to make the exercise of a right, though, depend upon the waiver of another right. We're talking about equal strength rights at that point. If we're talking about a privilege and we're extending an extension of a right, then that's something that an individual can make an educated decision on. But it's not appropriate to do that in the venue of conditioning rights upon the waiver of other rights.
Similarly, if the law used to be that you could carry a concealed weapon, and now the legislature is just saying, well, from now on, we won't consider it concealed if you tell us you have it. I mean, why isn't that a fair use of the legislative authority?
Again, I think that it can be as long as it's done right. And the second way that I would, I guess, approach the notion of it being done right is that there still has to be some avenue for a person to try to not incriminate themselves. So if the legislature had done something to the effect of reframe the statute such that the statute only criminalized giving false answers, in a manner similar to how the false reporting to police officers is done when asked about a weapon, then absolutely, that would be something that would be appropriate. The problem is really when the statutory scheme not only deters the exercise of rights, but also criminalizes the exercise of one's right to remain silent. And so pragmatically, while there's a functional way that the legislature could have done it, it was simply that this method of doing it wasn't the appropriate method of doing it. And I think that comes back to the premise of why we have the protection against self-incrimination, which is the understanding that while there's innocent people who are protected from this, it's guilty people who are also protected by this as well. And it's not a question of whether or not we can condition the exercise of rights upon following certain laws or being a law-abiding person, but that a person who's gone ahead and broken the law can't then be punished for trying to invoke and incriminate themselves in that sort of a setting. And so I think that the fundamental problem comes back to the coercion aspect of it. And when we talk about the coercion aspect of it, that really goes back again to the notion of this selective group, because it's this selective group that's being contacted, and it's only a selective group that's really being coerced in this nature. And it's already in a highly selective scenario, and it's already in a highly selective group that's going to be coerced in this sort of a fashion. And that's only individuals who are contacted according to 3102M, which means that it's only individuals who are going to be getting contacted in a reasonable suspicion setting. So the statutory scheme already recognizes that individuals who are going to be asked this question are going to be asked the question in the context of reasonable suspicion. So if we're talking about a highly selective group that is inherently suspect of crime, you can't really get any closer to that than defining the group to whom the law applies as those who are suspected of crimes. And that's precisely what the statutory scheme does.
Saying this statute only applies in a Terry situation?
Not only in a Terry situation, but that Terry is the baseline situation.
I mean, doesn't it apply in a voluntary contact between a policeman and a citizen?
Under CERNA, it could be extended in that sort of a fashion. And so under CERNA, if an individual is carrying a weapon, then theoretically, I suppose it could. I think the problem is that when comparing the statute to 3102M, and CERNA didn't go so far as to actually rule on that issue. 3102M does apply directly to involuntary settings specifically. And those involuntary settings can include things like traffic stops or reasonable suspicion stops. But even if we were to look at it from voluntary contacts, or even if we were to look at it from the perspective of involuntary contacts that are investigation-based, we're still talking about such narrow exceptions that the broad application is still going to be to individuals who are suspected of crimes. So, for example, in the state supplemental authority, the state cited to one case which indicated that it was appropriate to interview witnesses or to stop witnesses, and that was the Watkins decision. But in Watkins, they also noted that there was a very narrow exception, or that this was a narrow exception, and that in that circumstance, an officer still had to have reasonable suspicion that a crime had just been committed, reason to believe that this person not just had information, but had material information on it, and had to have a reason to believe that apprehending the person was the only real way to affect that information or obtain that information. And so because it's such a narrow exception, even if we talk about it in the context of voluntary contacts or involuntary contacts, which are still police initiated. The vast majority of contacts, and thus the focus of the statutory scheme, is still going to be in that Terry-based analysis. With that, I'd like to reserve the remainder of my time.
Thank you. Walsh. I know.
May it please the Court, my name is Assistant Attorney General Robert Walsh, appearing on behalf of the state of Arizona in this case. I'd like to address the standing issue first. When you take a look at the language of this statute, it prohibits failing to accurately answer a question about whether or not you're carrying a concealed weapon. That term encompasses two situations, one of which is lying and saying you do not have a gun on your person, as Mr. Warren did, or invoking your right to silence and saying, I'm not answering that question. Now, it's very important when you notice that distinction because, Judge Thompson, you were asking questions at the outset about standing. A person who lies to a police officer, even if they do not have the option of invoking the Fifth Amendment and they lie, they still are not protected by the Fifth Amendment. Now, there are four cases that I cited in my brief that I'd like the Court to focus on. One of them is United States versus Knox. Knox was basically a case that predated the Marchetti-Grasso line of cases. This is where the gambler was supposed to notify the government that they were engaged in wagering activities and to have a license. And Grasso also dealt with that registration. Well, Knox happened to be prosecuted for submitting a tax form that contained false information before Marchetti and Grasso had been decided. At the time, there were actually two other cases called Lewis and Carringer that actually said that you had no Fifth Amendment defense. And in that particular situation, Knox was prosecuted under 18 U.S.C. 1001. And he said, hey, I was compelled to give this false response. I didn't have the right to invoke. The Supreme Court said you don't have a right to lie. United States versus Wong validates this point. United States versus Wong dealt with a woman who was Chinese who had a limited proficiency in English. She was called before the grand jury. She was asked questions and she lied. And she tried to argue, and the court accepted the notion that since she did not understand the prosecutor when he told her, you have this right to remain silent, that she, in fact, legally and factually did not even have the idea that she could invoke. And she gave false testimony. And once again, the Supreme Court upheld that conviction. In fact, it said, indeed, and this is on page 180, the site is 431 U.S. Reporter, page 180. Indeed, even if the government could, on pain of criminal sanctions, compel an answer to its incriminating questions, a citizen is not at liberty to answer falsely. If the citizen answers the question, the answer must be truthful. So the Supreme Court in Wong and in Knox basically knocks out the underpinning of the argument that if you do not have this option to invoke your Fifth Amendment privilege and you lie because you think it's a better course, that somehow you're protected by the Fifth Amendment. That is fallacious.
But see, one thing that occurs to me about this statute is that it's not intended in most cases to invoke an incriminatory response. It's part of a, as I can understand it, a scheme that where the legislature has wanted to expand the lawful gun carrying, and it's just saying we think that it's okay for the citizenry to be armed, but they need to make sure policemen know they have a gun when they're dealing with them. So in those cases, it's not asking for a person to incriminate himself. In CERNA, as I recall that, they were talking to the guy, I believe it was a voluntary encounter, and asked him if he had a gun. He said yes. And then they asked him, are you a felon? And he said yes. So when they asked, do you have a gun, they weren't really trying to put him in jail for it. They just wanted to make sure that what they were dealing with when they were talking to him.
Judge Thompson, you've anticipated what I'm going to cover when I talk about why the statute, should the defendant even have standing, would still lose even though the statute, he could either invoke or answer yes or say no, that the statute is constitutional for the very reason you're talking about. This statute does not apply to
if a policeman asks a person his name, we don't usually construe that as being a request for incriminating information. Sometimes it's incriminating because, there might be a warrant for the guy or whatever else other reason. So I'm just maybe not seeing this statute as really involving the invasion of people's rights to silence.
Okay, I understand. The truth of the matter is that appellant doesn't even have standing to challenge the question of the constitutionality of the statute because you do not have a right to lie. And because you can apply this statute in this manner when someone lies and prosecute them under 13-3102A1B, this statute is constitutional. Appellant raised a facial challenge to the statute below. If the state can prove that the statute is constitutional in any circumstance, the statute can be withheld as being constitutional. Because he did not invoke his right to silence, and that's the actual predicate to his constitutional claim, he doesn't have standing to stand on behalf of those who do say, I'm not answering you.
At some point, do you want to talk about the stop?
About the original stop in this case?
Isn't there a claim here that the court should have granted a motion to suppress so we would never found the gun in the first place?
Well, essentially, Your Honor, the trial court properly.
The counsel didn't talk about it, but it's in his appeal, so it's something that we're going to have to address.
Okay. I could shift gears. I was hoping to talk about the constitutionality of the statute on its merits.
Okay.
But I could talk about the Fourth Amendment.
Up to you. You've got time.
Okay. I want to talk about the statute real quickly, though. When it comes down to the reason why the statute is constitutional, Judge Thompson, as you indicated, carrying a concealed weapon is lawful in Arizona. And in 2010, our legislature did away with the permit requirement. It allowed people to carry guns. And it was basically a compensation to law enforcement to be able to ask the question and demand a truthful response. Do you have a gun on your person? Now, first and foremost, this is different than Marchetti and Grasso and all those different cases that are cited by the Supreme Court. This is not inherently criminal activity at issue. This is legal activity, and this is a regulatory statute. Its purpose is to protect the public during what could be a very, very dangerous situation. This case illustrates that. You have 4 people in dark-tinted windows, all rolled up. Another officer on the scene sees that there's movement. The officers don't know what's going on. They ask at that point, do you have any weapons? Do you have any weapons? And the answer is no. And, of course, what do they find? They find the defendant with the gun hidden in his pants. They find a sawed-off shotgun in the back of the car, another gun in underneath the driver's seat. Now, when those officers are asking those questions, are they saying, oh, good, we have an opportunity to bust some prohibited possessors? Or are they thinking about the safety of the people who are at that Circle K? This car was stopped at a gas pump, and their customers. They themselves are in danger. And should they misconstrue a furtive movement from those in the car and think that it's a weapon, they might shoot at those people, even though they themselves were not doing anything to threaten them. This statute is designed to protect the public. It is regulatory in nature. When it's regulatory in nature, and in this particular case, by the way, I want to make sure I confirm something here. This statute is not intended to target those who are in a selective group inherently suspect of criminal activities. This applies to the 203,000 people who nonetheless have a permit so they could get reciprocity in another state. This also applies to every single person who is stopped during a traffic stop. I indicated in 2008, my supplemental citation of authority, there were 550,000 people who were stopped. That's a very large percentage when you consider how long, if you ask people in this courtroom how many people have been stopped by the police, you probably find most people here have during a traffic stop. And that is encompassed in the language of what does contacted by law enforcement mean. Now, the Supreme Court has noted in numerous cases, Maryland versus Wilson, Pennsylvania versus Mims, all these cases, they recognize how dangerous traffic stops can be because the police do not know who they're stopping. A large number of officers are wounded because of these types of things, and they have a right to ask that question. Now, when you also look at the fact that this is not a highly selective group, you could stop a citizen and say, did you see someone that we think there's a crime? Did you see anything? That person isn't inherently suspect of any criminal activity. And even those who are stopped under Terry, the Supreme Court in Wardlow indicated, we realize and we recognize, we accept the fact that many people who are innocent are going to be stopped and briefly detained. That does not make them part of a suspect class. When you look at this statute, it's intended to focus on safety. And the Byers case and numerous other cases, Flores, Boudet, they all recognize that you're allowed to stop someone and compel an answer. And that is something that you're allowed to do when you're balancing the needs of the individual against the society. And here, most people who have concealed weapons are going to have it legally. The problem here is that he's looking at the incidental effect of this statute that applies universally to a lawful conduct that is engaged in by the majority of people. And when it's an incidental effect, it's constitutional. This People versus Samuel case actually lays out the analysis very well. And I think it helps distinguish between constitutional and unconstitutional compulsions to give incriminating evidence about yourself. And one thing that's very important is when you look at Flores, it talks about groups of people. When they make this analysis, they're not focusing on the specific individual. They're looking at the universe of people to whom the law applies. So in Marchetti, when you have wagers, these people are dealing with the illegality of gambling and things of that nature, and they have to basically they're being compelled to identify themselves by having to pay taxes on their transactions and things like that. When you look at Albertson, it's focused exclusively on communists. When you have those types of statutes and the only people who have to come forward are those committing criminal acts, you have a problem. But when you look at Flores, Flores said, look, we're talking about anybody who wants to ship weapons. It's a lawful activity. We have to look at the group. The flaw in his analysis is that he's looking just at the individual. He tries to distinguish Flores on the fact that you have to look at who is asking for the information. And he says, well, it doesn't matter. It's just, Ecuador Airlines. Well, actually, when you think about Wong, when she was called before the court, who called her? A prosecutor. He brought her into the grand jury room, put her under oath. In Boudet, what happened? A police officer pulled her over and said, give me your license and your registration. I don't want to. That wasn't voluntary. That's not the reason why you could distinguish those cases. And you look at the Flores case, I indicate that they collect other cases where they uphold compulsory disclosures, currency requirements. Who do you give that information to? A customs agent. When you come across the border and you have to declare you have amphetamines, that is subject to tax, who do you give that information to? That type of thing is very important. Now, the location of this is in the criminal code. That doesn't matter, because you could have statutes that are in a traffic code, and the defendant can argue, oh, this is intended to incriminate somebody. It doesn't matter, it's in the traffic code. In Flores and People versus Kurgenbach, which is the California case I cited, these statutes are, in fact, in the criminal statutes, but the court looks at things like I've talked about. Is the activity regulated lawful? Is it regulatory? Is it something that's focused on a small group of people who, by nature of their incrimination, are going to identify themselves as criminals and to them alone? Those types of things are very important to keep in mind. Also, what's the purpose? In Flores, the court said, well, what's very important to us is that this statute is designed to help states protect their citizens by regulating the influx of weapons across their borders, and we're going to give the carriers who are responsible for transporting it the ability to help the federal government there. So neither of those distinctions matter. Now, Judge Thompson, I do want to talk about the stop, and I'll mention it very briefly. And Judge Warner relied on a rationale that was different than what the officers had relied upon. In State versus Whitman, this court indicated that what you have to look at is whether or not there's an objective basis for that stop, and Judge Warner found it.
Did the officers rely on the second turn?
They did. They relied on the fact that he didn't...
The turn into the Circle K?
No, I do not believe that they did. I believe that the state introduced testimony that they observed that illegal turn. And as I put at the end of my argument, and argument number one of my brief, that is an independent basis for upholding this search, because, I'm not aware of any law or any traffic code that says that once the police put their lights on and try to pull you over, that you have to disregard every other traffic law that you...
Well, I'm not sure that that's the way it happened anyway. It looks to me like both of the police officers testified that they started the turn in the Circle K and then they put their lights on. It was just the police report that suggested otherwise, right?
That's correct, Your Honor. And I know the state advocated for it. The trial court didn't find it. It rejected that testimony and indicated that, if I recall the minute entry correctly, that he put the lights on as the Impala was getting into the Circle K. The lights were on during the course of entering.
Thought they were lying?
What's that?
She thought they were lying in court? I mean, it was just a police report.
I know. I can't understand why Judge Warner ruled the way that he did. But obviously, you know, my fallback position is that illegal right turn furnishes another basis for upholding the stop.
Let me ask you about that, because that, to me, seems like the more clear-cut traffic violation, but Officer Barton said it was the initial driving behavior at the Glendale exit ramp, and that's what Judge Warner found, I believe. So what's your argument as to our authority? Because the turn into Circle K, to me, seems like a much more clear-cut traffic violation.
It certainly is, and this court, you know, will look at these legal questions de novo. You have to defer to the findings of fact by the trial court unless there's clear error. And the cases that I cite, the State versus Holmes case from the South Carolina Supreme Court seems to support my position there. The defendant blew a stop sign and sped after the initial alleged illegal stop, and the court could uphold the search on this basis. But my brief, I want to make sure, Judge Thompson, since you brought up the question of the search, is there anything in particular, since I have 4 minutes, that you would like me to elaborate upon that I haven't in my brief?
Did you want to say something? Did you want to say something about the vouching argument?
Sure, I'd be happy to. Judge Winthrop, do you have?
That's what I was going to ask.
Oh, sure, I'd be
Sort of
happy
the
to.
Rules the evidence rule 610, a constitutional issue where a prosecutor essentially arguably cloaks Officer Barton with the mantle of religious credibility.
Okay, I understand that. When you look at that particular situation, the officer was asked essentially, could you lose your job for perjury as a police officer? Yes. Could you lose your other job as a pastor? Yes. And this particular testimony came in and it was objected to on the grounds of vouching. It wasn't until the following morning that appellant argued and said, well, wait a minute, put that together with the earlier testimony about him having gone to a couple of religious colleges and gotten degrees from Grand Canyon University or a theological university. You're trying to bolster this witness by way of cloaking them with some sort of shroud of truthfulness because of Christianity. It took that long for defense counsel to recognize that this may not have even dawned on the jury. The prosecutor was just merely trying to say, look, you could lose your jobs if you lie, and this court in State versus Palmer, the Supreme Court of Arizona in State versus James, all the other cases that I've cited, you can bring to the jury's attention the fact that adverse consequences will come should you not testify truthfully. So the court said, okay, this is a close issue, so let's just assume for the sake of argument that it was improper. I'm just going to say that for right now. You have the jury instruction. Now, this is not structural error. State versus Thomas, the Arizona Supreme Court reviewed the facts of the case and determined the facts were such that you had to find reversible error. State versus Stone, they found corroboration of a rape victim whose Mormon faith had come out, and they basically said there was corroborating evidence of her testimony, so we're not going to find that to be problematic. Well, here you have not just Officer Barton, you have Officer Glidwell, who's standing by the Impala, but he hears a clank of metal, and he sees the gun that Officer Barton's taking up from the ground. You also have other witnesses who see the crack cocaine fall out of the defendant's pants on the floorboard where he sat. You had other officers come back to deal with the crack cocaine that was found in his shoe. You have the defendant making statements that are verified. This is small-time SHIT. Can you just drop it? He indicates that he's being sentenced. In fact, he is being sentenced. So you have evidence that substantiates the witness as separate and apart. So this was not a case that rested upon Officer Barton's credibility. The jury instruction that appellant, the defense counsel, himself crafted is presumably enough to cure any prejudice because jurors are presumed to know and to follow the instructions of the jury. And this was basically isolated moments in a trial that lasted 3 days. So when you look at all these things, and you also have the doctrine that you shouldn't infer. You should not basically assume that the prosecutor means the worst possible construction from an ambiguous statement, nor should you infer that the jury would do the same thing and say, oh, I got it, he's a religious guy, therefore he must be telling the truth. And that's not what we have in this case. And I have 43 seconds. I'll be happy to take any last minutes. Thank you very much. I appreciate it.
Mr. Steinfeld.
Thank you. Since we went into it on the answering side, I'll go ahead and try to address quite briefly the stop and the 610 argument. Regarding the stop, and more specifically the third incident of the stop, the right-hand turn into the Circle K, I think pragmatically there comes into dispute a difference between refusal and an attempt to cooperate. When we look at the state's cases that were cited, when we look at U.S. v. Sprinkle, U.S. v. Holmes, U.S. v. Bailey, those all dealt with situations where a defendant fled once the lights were turned on. When we look at State v. Barron and In re JLBM, those were all situations where the defendant gave a false identification information. Even the closest call would be Clark v. U.S., in which the response was for an individual to threaten a police officer. Those are very different scenarios from when a person's illegal or problematic conduct is simply in an attempt to try to comply with the police officers. And from that perspective, Officer Barton's testimony at the evidentiary hearing becomes quite important. When Officer Barton noted that it's quite common for people to drive stupidly, and then when lights are turned on to make stupid moves like an abrupt move to the right. I don't think that we can count that, because ultimately the right-hand turn into the Circle K was an attempt to comply, not an attempt to avoid apprehension or anything of that sort. And then regarding the 610 argument.
I mean, do you have to determine after the fact which one it was? Isn't it enough at the time the officer saw the guy fishtailing across 3 lanes of traffic into the Circle K? I mean,
I don't think that that's a fair characterization, Judge. And I see I've run out of time. May I briefly answer? I think that it can be enough, but ultimately that's not what the testimony was.
I mean, even if later the guy says, look, I did the weird maneuver because you put your lights on. I mean, what matters is how it objectively appeared to the police officers at the time of the stop, right?
But then we still default back to the trial court's findings, and the trial court's findings was that it was in response and in an attempt to try to comply. With that, I stand by the requests in my briefing.
Thank you, counsel. We appreciate the briefing and the argument that was presented on this matter. We will take this under advisement and issue a written decision in due course. With that, we are adjourned.